Are we live? Can you check?
Yes, ma'am, I'm gonna check too, but we should.
Are we live?
Yes, ma'am.
Good morning, everyone. Thank you for coming this morning. And Lisa, if you would call the roll, please.
Okay. Eric King,
Here.
Courtney Kennedy. Note that she is not present. Mike Mason,
Here.
Dennis Moore,
Here.
Harold Clendenin.
Here.
Okay.
All right, I guess everyone got the minutes from the last meeting. Had a chance to read them and everything. So if you would, we have a motion and a second to approve the minutes.
Move the motions approved as Smale. Second.
We have a motion and a second. All those in favor?
Aye.
Opposed? I would like to thank everyone for being here this morning. And we've got a lot to discuss. And
This is the
Mr. Chairman,
yes,
I'm Robert Newcomb. I represent former Officer Byrd. I have a preliminary question and a comment. One is, did we give notice of at least 2 hours to the news media in Faulkner County that we're having this special meeting?
yes, sir. It goes out with the meeting notice. It went out last week.
Okay, and secondly, I'd appreciate it in the future if we're gonna have a meeting involving, this case that involving me, that I be notified. I learned of this meeting, thanks to, counsel for the city who, called me after she learned of it from, she told me Chief Harris had heard about it. So I know y'all had an earlier meeting setting the time frame and all that for it, and I didn't know about that meeting either. So if for some reason we have another special meeting on this case, I don't care about others, I would appreciate being notified.
I know the other, one with the minutes, it showed up last week and everything, so. That on the date for the August the 20th, I do know that, so. But okay, well,
I mean, what could have happened, y'all could have said it, and I could have been in the middle of a federal court trial and not been available on August the 20th. Where if I'd known about it, would have been here, we could have avoided that potential problem.
right, okay,
Fair enough.
that will be duly noted. Thank you. Okay, everyone would like to read over this? Anything in there that, what do we need to do on that? Just-
Charles is y'all's. Did you bring that copy, Charles? This is what they're doing.
Miss Lisa, is this ours to keep? Can we make
Yes.
that?
That's your copy.
Does it need to go over there? That's what I'll do now.
That's a question from Charles.
Charles, is there anything there that you would like to go over with us or call to our attention or anything?
If I'm reading this correctly, this is a joint stipulations of fact. It looks like all the facts at issue have been stipulated to with one set of stipulations subject to, and I'm reading this as a joint submission, so it doesn't look like there's any argument, but some of the stipulated facts are subject to the underlying witness being present, subject to cross-examination. So you'll see that in there. There's two kind of groups. That first one is facts not in controversy. And I'm reading this more as a guide to the commission, so the commission knows what's gonna be an issue at the hearing.
Can I go ahead and get a copy of what's been? Thank you.
I'll have to go make you a copy.
Okay, thank you.
Sorry,
I think she's got one.
I have one.
Thank you.
Has everyone had a chance to kind of read through that, see if there's anything? If not, we can go on to, the pre-hearing motions from both parties or from. If you have anything on pre-hearing motions?
Yes, sir. I assume we're having some type of record being made that would be able to be filed in circuit court, because this is part of the proceedings. And if there's an appeal, either side can appeal. The court would want to know what happened at this meeting, so I don't see a court reporter. So is there some way that there's a record being made that a judge would be able to look at it and review it?
I think it is being recorded, isn't it?
Yes, it is.
So that would be able to be certified as a record that would be admissible in circuit court? I guess I'll ask Charles that. Since either side can appeal and it's based upon the record made before this commission and such other evidence, are we gonna have like a transcript we could have from circuit court in a pretrial hearing?
Right, so I think as far as the actual hearing itself to be conducted,
We'll have a court reporter
there's a court
there.
reporter set up for that per statute. These meetings that occur before the actual hearing are recorded, video recorded, and presumably, like any other video recording in any other case, it could be introduced as part of the record, and I imagine would be introduced as part of the record if there were an appeal, for example.
Well, I just, I know we're gonna go forward and I'm not gonna, but I just wanna make my note for the record that I have a problem. There's no court reporter to transcribe this. I mean, you wouldn't have a pretrial hearing in circuit court or district court without a record being made by.
Well, you'd always have no record in district court, right? Circuit court, you would have a court reporter, but in district court.
Some district courts now have recorded, and so.
The video arraignments, yeah, if they're acting as a circuit judge pursuant to the administrative order of that district.
But I note my concern and not by participating, I'm not waiving any issues that may come up with, since there's not a verbatim record being made by a certified court reporter or certified recording system. I have a couple of pretrial motions, Mr. Chairman. One, I don't know where we stand on, and that is the motion for the disqualification of Commissioner Kennedy. The last correspondence I've seen from her was that she was not going to voluntarily disqualify. I didn't know if she's indicated to the commission a change of position or whether we need to go forward with asking for a ruling from the chair on whether she legally can participate in it or not.
I don't think that she has said that she is not, I mean, she is going to participate.
Well, since she has indicated she's going to participate, I would ask the chair to rule that she's precluded from hearing this matter. As you can see from the stipulations, both parties have listed Lieutenant Kennedy as a witness. And so there's no argument that he's gonna be a witness, in this proceeding. The next question is, I submitted a Attorney General's opinion that a commission like you all in this proceeding is acting in a quasi-judicial manner. And so that, as the AG's opinion, and I can cite some cases, say that you all just are bound by the same canons of ethics as a judge is. And one of the mandatory disqualifications under Rule 2.111 subparagraph 2D is that says spouse is likely to be a material witness in this proceeding. So I ask that one of two things either occur then. Either Ms. Kennedy disqualifies, or I'll make a motion in limine that Lieutenant Kennedy is not permitted to testify. Because otherwise you all would be, one way or the other, there would be a violation of the code of ethics that apply to you. And Ms. Kennedy, and the only way to eliminate it, if she's gonna sit, is preclude Lieutenant Kennedy from testifying.
If y'all would like to hear, I'll give a response from Conway PD.
Please do.
We did not file a response to the petitioner's motion to disqualify, particularly because I really think that is their motion with the particular commissioner that sits on the commission, and in this case, it's Courtney Kennedy. Did not file a response. I'm not going to join with Mr. Newcomb, but I do think it would be appropriate in this circumstance for her to recuse. I was here at the last meeting. I didn't offer any opinion on it. I was just here for scheduling. But I think there was some discussion that maybe that's her decision, that that's something that she would have to decide herself. I don't know if that is true or not, but I will state that because Lieutenant Kennedy will be a witness and he is a key witness, I do not want him to be precluded from testifying. And I think that it would be appropriate that because he is her husband and will be offering testimony, that it would be appropriate for her to recuse.
Okay.
Well, I have a question on that, a follow-up. Is that her call? Or my understanding is this commission doesn't have the authority to recuse any member of the body, and that would strictly be relied upon her call to recuse or not to recuse. Am I correct on that?
So I will leave that to your city attorney who knows much more about that to advise you on it. I think he provided advice at the last commission meeting, but I would rely on his advice.
Yeah, if the chair decides all matters relevant to pleadings and admissibility of evidence, so it's not a vote by the commission. So every time there's a motion in limine or a motion to recuse, the chair is the one that issues the decision, so y'all wouldn't be voting on it. You can certainly ask questions on any matter that comes up. But I do think that the chairperson of a commission like the Civil Service Commission does have the inherent authority to remove a member from hearing a matter if the chair decides that there is a conflict of interest.
Yeah, okay.
Otherwise, there would be no rule or order to the proceedings, right? And just like Mr. Newcomb pointed out, this commission sits as a quasi-judicial body. And so just like a judge would recuse himself or herself if a witness in that case likely to come up is someone that's related to that judge. I can't tell the commission what to do because that's not my role. I can give general legal advice, but I think counsel for the petition respondent have made the matter pretty easy.
That being said, I think that it would be a good idea if we did recuse Courtney from sitting in on that. So we will recuse her from participating.
Thank you, Mr. Chairman, and just for the record, I've never met Ms. Kennedy. I have no personal feelings negative about her, and it was not done for, because I had a dislike for her. I thought that was what the law was. My next motion in limine deals with the issue of one of the charges against, Ms. Byrd, and y'all have the letter of termination was one of the agreed upon exhibits, in stipulations, and it says in Chief Harris's letter, furthermore, during your formal interview with the assigned investigator, portions of your statements were found to be untruthful in that they were contradicted by evidence obtained from the car camera system and body-worn camera. It doesn't tell us what it was. It'd be like I sue you and say I'm suing you because of a car wreck, and don't tell you what car wreck, where the car wreck was, when the car wreck was. Or I say, I'm taking you to trial for murder, but I don't tell you who you murdered, when you murdered them, or what level of murder you committed. And the statute that I cite is 1451-308, which deals, one of the provisions dealing with the operations of the commission. And it says no civil service employee shall be discharged, reduced in rank or compensation, or suspended for more than 3 days without being notified in writing of the discharge, reduction in rank, or compensation, or suspension. We have not been told what the cause of the untruthfulness is. I can speculate, I can guess. I've asked for discovery. That was one of my questions in it. The city took the position that there was no requirement that the city respond to written discovery like it was a civil case, which to a very strong point, they're right in the sense that both the Arkansas Rules of Civil Procedure and the Arkansas Rules of Evidence, by their very terms, only apply to court proceedings, not civil service proceedings. So either one of us relying, whether it's in the city's motion in limine on witnesses or an objection I may have, those rules don't apply. And as far as I can tell, if I'm mistaken, please correct me, but I cannot find where the commission in its rulemaking powers for trials before it have adopted any by either direct or indirect, adopted the Arkansas Rules of Civil Procedure or the Arkansas Rules of Evidence as guidelines or rules for this commission. If I'm mistaken. So I go back to the statute. We have not been given what the cause is. We're saying it happened during, there's 2 interviews and y'all get to watch them, and they're probably combined about over an hour long. Cameras, I'm not sure if they're talking about her cameras, other people's cameras, and we got hours and hours and hours of camera. And in the interviews, Lieutenant Kennedy never said, you know, I believe you're violating untruthfulness by saying that the sun rises in the west when in fact it rises in the east. I'm just taking that part of it as an example without getting into the merits of the case. So I'm asking, since they didn't give us the cause, you know, what was the fact, what was the statement made that they contend was false, and what did they contend was the truth? We had no way to defend ourselves at the hearing on that charge. So I'm asking that they be precluded. They haven't even corrected it as of, what time is it? You know, they haven't corrected it as of now. I still don't know what the untruthfulness is. I'm not saying you can't be charged with untruthfulness. That isn't my point, but I think fundamental fairness requires that we have adequate notice of what she supposedly was untruthful about, which if you look at dictionaries, untruthfulness is synonymous with lying. And lying is, and you know, as we all know, is we can look at the dictionaries and intentional material misrepresentation made for the purpose of deceiving. So tell me what she did and we'll defend it, but I don't think we should hear it at the hearing Wednesday or whenever we get to that part of it and then have to defend it on the fly.
If I may respond?
Yes.
I filed a response to that motion in limine on behalf of Conway Police Department. What Mr. Newcomb is stating, he's citing to a statute, right? A state statute that says what a public employee has to be provided with when they are terminated, okay? And that statute, I'll read it again so we're all very aware of it. Says no civil service employee shall be discharged, reduced in rank or compensation, or suspended for 3 or more days without being notified in writing of the discharge, reduction in rank or compensation, or the suspension for 3 or more days and its cause. That's what it states. That's all the statute states, okay? As we know, in my response, I attached a copy of the termination letter. That letter is lengthy. It identifies first the violations of policy that according to Conway PD, Ms. Bird violated, the policy she violated. One of those was the policy on truthfulness, right? Further in that letter, it gives additional information about the administrative inquiry, looking at the response to this mass shooting that occurred on April 13th, 2025. And with respect to the truthfulness, it identifies that Ms. Bird, during your interviews, the administrative inquiry interviews that were conducted by Lieutenant Kennedy, it says during that, we found that some of the statements you made were untruthful, right? And it goes further. It says, how do we know those were untruthful statements? We know they were untruthful based on evidence uncovered in body cams and in dash cams. So she was provided the cause, right? What Mr. Newcomb is wanting is very specific language on what the untruthful statements were. That is not what the statute requires. The statute says provide the cause. We did that. If the legislator wanted there to be very specific language about this is the time, the date, the specific statement made, then the legislature could require that, but they don't. They simply say provide the cause, and we did. That is sufficient notice under this statute. Now, Mr. Newcomb says it would be like if I sued you for a car wreck, but I didn't tell you when it occurred, didn't tell you what it was about. That's not this. Ms. Bird knows the dates that she was interviewed. The totality of those interviews are about an hour and a half with a bunch of blank times in between. So the amount of talking isn't a whole lot. She knows the date. She knows the statements that she made because she has been provided with the video recordings of those interviews. She knows the context. What were they talking about? What was she being pressed on? And Mr. Newcomb says there's no indication in those interviews what possibly her untruthful statements could be. And I would submit to this commission that they do provide guidance on that. Lieutenant Kennedy is asking her about things and will say, no, it can't be right. Let me tell you why. Let me tell you what I saw on a dash cam. Let me tell you what I saw on your route. That's how I know that the statements you're making cannot be true. So that's contained in all of the audio files. She has audio files and video files with audio of the interviews she gave. So she knows the cause that's provided in the termination letter. She has the ability to review all of the statements she made. She has the ability to review the statements that were made by Lieutenant Kennedy when he presses her on her answers. So she knows that. So to come in here and try to say, I have no idea what the untruthfulness is based on, that does not add up with everything that she's been provided and the information that was provided in her termination letter. So again, back to the statute, what do we have to provide? We have to provide someone with notice, right? Written notice. You are being terminated, right? In addition to stating you are being terminated, we have to say, this is the cause. We did that. That extensive termination letter that we presented in our response establishes that. In addition to that, we identified the time when the statements were made, the context in which the statements were made, and how her statements were contradicted. And Ms. Bird knows that because she sat in those interviews. And so we would ask that we be allowed to present evidence on that issue and that the commission not decide at this time that we be precluded from presenting such evidence. Ms. Bird has notice of that, and that we be allowed to proceed at the hearing.
This is on the moving party. I think I get to have rebuttal to her statement. It would be the normal procedure in court, but I know court doesn't apply here, so can I respond to that, or?
If you think you need to, yes.
My cause is what would be not the rule, but the actual statements. Is she saying the entire statement was false? Was there parts of it false? Did she explain statements that, to the satisfaction of what? I don't know why it's so hard for the city, unless it's just trying to hide the ball and sandbag her, to say, look, we're saying you lied on A, B, and C. That's, if I was charging somebody with being untruthful in a perjury case, which isn't applicable, I would have to spell out what that false statement were. I couldn't say your entire testimony. It's contained somewhere in there. So I think all we're asking for is fair notice. Not that they can't try to terminate her for truthfulness. I just think that we should be told, and they have chosen deliberately not to. They've deliberately chosen to be evasive on responding to it. Even today, can you tell me what she's being charged with, word-wise, as being false? No. And would you want to go to trial the day after tomorrow without having been told that? They could have answered the interrogatories even though they didn't have to under the rules. We put them on notice forever that we just wanted to know what you're saying was untruthful. And what's so hard about that?
And I thought that's why we were having the hearing supposedly on this coming Wednesday, so we could bring out all those facts and everything.
But my point is a little bit different than, the points can be brought out. So if you say I don't get to know what they're gonna claim in specific language is what is false, that's your ruling, but that's my objection. Is all I'm asking is that they be told, tell us out of the hour and a half of interview in the body cameras, and whether it's anybody else's body camera they're relying on, just what are they saying was the false statement? That it's not a complicated treatise on taxes. Just, tell me you said this and that's not true. And then y'all decide whether that in fact was untruthful at the hearing. On that, all I'm asking for is what are they claiming, and they're gonna ask you all to find to be untruthful. They have to, otherwise it's a guess.
Would you like to respond to that or anything?
All I will say is that, first, the termination letter did not state your entire statement is untruthful. It said portions of your statement were untruthful and contradicted by dash cam and body cam. And during her interview, she was presented with various pieces of evidence that, according to Lieutenant Kennedy, demonstrated that what she was saying could not be true. So to sit here and say we have no idea, Ms. Bird has an idea of what she stated in that. They were her statements, and she was challenged on them.
Thank you. Is there Anything else that needs to be brought up this morning or anything?
So I have two things.
Okay.
I agree with, on the subject of, that we just talked about, no, there's, like she said, I think they have two things. I don't have anything else.
Thank you.
So on behalf of Conway Police Department, I filed a motion in limine. I'm happy to give you all a moment to review that, and if you want to let me know when you'd like to hear argument.
Sorry about that, I thought I had it turned on.
Mr. Chairman,
Yes.
I also had filed, and I don't know if Ms. Mabry gave out my response or not when she gave out the cities, and I didn't know if you all would want to read that before we got into the oral argument by both parties, where you had both sides sort of in view, in front of you, and have looked at it before we started arguing. That's up to you all, but that would be somewhat the normal procedure, where you look at both written and then hear all oral argument.
Are you talking about the ones that you found,
Yeah.
you and Angie found?
Yeah.
There, I've got one more. Just a second, I'll get you another copy.
we can get back to your two thoughts that you had.
Yes, sir. So I think I can speak on behalf of Mr. Newcomb and myself. We appreciate y'all reading my motion and his response. As an initial matter, I will state, I submitted this motion in limine. It is long, but that is not strange. I submit these often in court, and sometimes they are twice this length, if not more. But I appreciate y'all taking the time. In addition to that, one of the reasons that I include background in a motion in limine is to provide some context for the relief that I'm seeking. It would make no sense to give y'all a little bit of information here and there without the background to go, this is why I think what I'm stating is irrelevant. So that's why I provided, I think, the limited background that I did in my motion in limine. I will also state, and I agree with Mr. Newcomb, that the rules of evidence do not apply in a Civil Service Commission hearing. However, the Civil Service Commission can, if it wants, use some of those rules as guardrails. And I think guardrails are important for any hearing, whether it's in front of the Civil Service Commission where you can use the rules or not, or in front of circuit courts or district courts where you have to use the rules. But they're there to provide some type of guardrail and to provide that, without them, someone could come in and testify to anything, right? That may be wholly relevant or completely irrelevant. And so the reason that I cite back to the rules of evidence is I think they provide those guardrails. The commission can go with them and go, we think this is good, this would help us through this hearing, or the commission can put them to the side, either way. But again, I think they provide guardrails, and that's why I rely on them in my motion. One of the primary things that I bring to the commission's attention in my motion is that I believe that one of the positions that Ms. Bird is going to take is that this shooting never should have happened. That Conway Police Department erred, was negligent in not breaking up this party beforehand. And because of that, commission, please look that way, right? Don't look at what I did. And as we know, based on this termination letter, her termination was based on her response, right? What did she do when the mass shooting occurred? Doesn't matter why it occurred. Doesn't matter if someone should have broken it up earlier. When you're a police officer, you respond to whatever incident happens on your watch. And that's what this case is about. She was terminated because CPD felt that the response was inadequate, that it violated numerous policies of CPD, that she did not respond with urgency, did not respond with full lights and sirens, did not respond on the most direct route. In addition to that, afterwards, when she was interviewed, they found she wasn't truthful and she was insubordinate. So CPD is not taking any position that any actions before the shooting that Ms. Bird took were wrong. In fact, I think she was doing good work out there, right? That doesn't matter. CPD is also not stating that any of these policy violations were a result of what she did once she responded, right? She was out there, she was tending to people, tending to injured individuals, right? Doing her job then. CPD is not saying anything then violated a policy. So what are we looking at here? What is this appeal about? The termination, just Brittany Bird's termination, and the basis for that. The basis for that, as presented in the termination letter, and as Ms. Bird knows, is related to her response. Shots fired. What does she do? Right? She calls in the shots fired. What does she do after that? What is her response? How does she get there? How fast does she get there? What emergency equipment does she use to get there? Right? That's what this is about. And we anticipate in looking at their witness list and what they state people might testify to, that what they're trying to make this is a referendum on whether Conway Police Department should have broken up this party earlier. That is just not relevant. And if we go down that road, it's going to be a very lengthy hearing to address all of that. And that is not what this hearing is about. Again, whether or not the party should have been broken up earlier, it doesn't matter for purposes of why she was terminated. Again, as a police officer, you are to respond whether you agree with how an incident came up or not. And in this case, we're talking about a very serious incident, a mass shooting where 2 people died and 9 were injured. It is all about her response. So for them to try to parade in witnesses to talk about what should have been done before that is completely irrelevant. It will confuse the issues. It will make this hearing much lengthier than it should be otherwise. Facts of this case, the facts of this appeal are pretty simple. Shots fired, what does she do? Right? What was her route? How did she respond? Was it with urgency? That's what this is about. She was not disciplined for anything prior, not disciplined for any of her response once she arrived at the park. That's what this is about. And so that's why I cite to the rules of evidence that any other testimony, evidence about how CPD handled, right, at the large gathering, it would just be irrelevant. And I have other reasons set forth in my motion, and I know that I talk about very specific witnesses. I think that the commission can do what the commission would like to do. It might be more appropriate in the hearing as they ask to call a witness, that because now the commission has the background, right? And so I know it would take a lot of time for us to go witness by witness and for me to give you my reasons, although they are in my motion. So I'm happy to stand down on that until we get to those particular witnesses. But that is the overall position of Conway Police Department. This is not a referendum on what Conway Police Department did prior to the shooting. It's about her response to the shooting, a response that other officers were required to take as well, no matter how it occurred.
Thank you, counsel. First, there's more than just what she said for y'all to decide. So other evidence is important. She acts like the only thing for you to decide is whether she violated the rules, not conceding she did. Y'all, you're only halfway there. Besides the rule violation, you also decide whether the punishment was appropriate. There's two cases I've given your counsel, that and the other counsel. One's Little Rock Police Department versus Phillips. The other one is the City of Van Buren versus Smith. And in both those cases, the circuit courts let in evidence not related to what the rule violations were. And the court felt that that was appropriate. It said the circuit court was appropriate in letting that in, because one of the things you look at, and in both of those cases, the Van Buren case and the Phillips case, I can go through a bunch of other cases I've tried. The commissions always look at what type of an employee do you have. So the witnesses, for example, on her job performance outside that day would go to helping you all decide what would be the appropriate punishment for Miss Bird. You know, had she been suspended 10 times before that, or received the Medal of Valor like we put down? You know, did she, as they want to say, we just want to talk about her response. And so a lot of the witnesses will talk about that she's asking to exclude about that her method, her route was the most appropriate under the circumstances. If you don't know all the circumstances, how they came about, what people saw, that people didn't report to officers didn't report to supervisors that they had citizens come up to them that people were waving guns in the park and there was no response by the police to it, is what was the situation and how did it come about that what Miss Bird faced? And then they want to claim that it was 5 minutes. Well, we have an expert that will show some of the Lieutenant Kennedy's technological representations may have been altered or modified. You know, if we're gonna talk about it, let's talk about the whole thing. Let's talk about that weekend. You know, what was Miss Bird doing? Was her total activity that weekend such that any mistake she may have made, and they claim, let's take the not responding with lights and siren, we'll dispute that. She didn't respond with them, but we'll explain why. You can decide whether, and their own rule says that the officers use discretion. Not that there's a flat black and white rule that says I shall do this. So if you don't have the whole circumstances why, and I remember another one, they're saying they don't think the record drivers are important or should be allowed. Chief Harris's statement, it says at the time of the incident where she was, you had a clear line of sight to the area where the shooting occurred. Well, the people they want to exclude, whether from the street department or the record drivers or record employees or others, were standing right where Miss Bird was, right next to her or in very close proximity. Do you think they might have some relevant testimony whether this statement by the chief is accurate or not, and y'all making a decision? So I ask you not to grant the motion in limine. I can go through it, and I think her suggestion is to hear them or see, because there might be things, for example, that you would think is relevant from the employee, but other things might not be relevant. Was it relevant that somebody from the west side of town with no traffic got to drive with that blue license siren at over 70 miles an hour through the streets of Conway with no action taken against them? Does that have relevance to termination? So I think that trying to make a ruling on the motion in limine without hearing the witnesses, or at least having an opportunity to have a more detailed one on each of them, is a suggestion I do agree with counsel on. And just for example, the record drivers, what route they took to tow the cars to their record yard wouldn't be relevant. If they were standing as far as you and I are apart from Officer Bird when the shots were fired and what she could see, that might be really relevant about why she took the route that she took. So we're in sort of a thing. I'm not trying to say, look at this, whether Miss Bird did right or wrong. Let's look at the total. That's what the chief said was gonna happen with this internal affairs investigation. That is what he said in his news conference, that he was gonna have an investigation, and this is the only investigation that's come forward, this AI 24. So let's talk about, that's part of it. Let's talk about the whole thing, the good, the bad, and indifferent done by whether it's Chief Harris or Miss Bird, where y'all can decide whether under those circumstances, even if she violated a rule, should she have been terminated? In the totality of the circumstances are important. I can remember one where a police officer shot at a fleeing suspect. The city of Little Rock said he did wrong and shouldn't have had the punishment reduced to a letter of reprimand. The guy was wanted for his second home invasion, rape, and murder. And this judge at oral argument, this Court of Appeals judge said, well, maybe his punishment should be that he goes to the firing range for 30 days where he doesn't miss the next time. So the totality of the circumstances are important, and the only way you can have that is hear all of the evidence, not just a less than 5-minute part of it.
May I reply? Are you done, Mr. Newcomb?
Yes.
Okay, may I reply? First, Mr. Newcomb referenced two cases, Little Rock versus Phillips and City of Van Buren versus Smith. I reviewed those cases, right? And he's talking about other evidence coming in. Right? What kind of evidence came in those cases? Certainly, other evidence can come in, right? What we're talking about, what I'm talking about, what this case is about her response, okay? Other evidence does come in if it's determined to be relevant, right? So let's talk about Little Rock versus Phillips. In that case, they were presenting evidence of, well, these other officers have committed the same offense and they did not get the same punishment, right? That's relevant, right? You can bring up all day long in these types of hearings, listen, this officer was treated differently, this officer did the same violation, and this officer didn't get the same disciplinary, right? That's a piece of evidence that could be relevant, and I understand that, right? Not applicable to this case. Now, certainly, they might bring in that type of evidence, and I wouldn't oppose it. Right? You can bring in that evidence. I think that's relevant. You can absolutely bring in that type of evidence. So, Little Rock versus Phillips doesn't stand for the proposition that you can bring in tons of evidence about what happened before a shooting, and that evidence somehow demonstrates that the party should have been broken up and the shooting never should have happened, right? That's irrelevant. You can bring in evidence about other officers not receiving the same treatment, and I get that. That's the Phillips case. Then we talk about City of Van Buren versus Smith. In that case, other evidence was brought in other than what happened that the city had said the individual was terminated for. But what was that other evidence? That other evidence was evidence that, hey, I wasn't terminated for what happened on that day. I was terminated for some other actions that I took. And so they brought in evidence of the other actions the officer had taken, right? That's not this case. I don't think there's any argument that Ms. Byrd was terminated for her actions during her response to the mass shooting. So again, that case does not support Mr. Newcomb's proposition that evidence about this party should have been broken up beforehand, this is what they knew beforehand, that any of that should come in. So those are those two cases. And I want to make sure that we are talking about the same thing. Mr. Newcomb talked about certain evidence that would go towards the response route, right? Would go towards how she responded. Fair game. That's relevant. I'll be presenting that evidence. I don't have any fault with him bringing that in. I have no argument that it should be kept out, right? He wants to challenge the data, right? GPS data, timestamps. He wants to challenge that. That's fine, right? That's what we're presenting as evidence that shows her response. Route she took, how fast she responded, lights and sirens. That's all fair game. Bring it in. I'm absolutely fine with that, and I'm not arguing that he shouldn't bring that in. So I want to make sure that we're all talking about the same thing. What I'm talking about is don't parade people in here to go, oh, well, that party was getting too big. Should have really broken that up. This is not a referendum on what happened prior to the shooting. And I understand that this investigation covered the entire CPD response. There's no doubt about that, right? But Ms. Byrd is not appealing the entire IA, the entire investigation. What she's appealing, and the only thing she has standing to appeal, is her termination, right? What did that investigation find about what she did, right? That's what she's appealing. This is not an appeal of everything they found in the entire investigation. This is an appeal about the finding that she violated certain policies as they found in that investigation, and that they determined she should be terminated for those policy violations. That is it. She does not have the right to appeal the entire investigation and bring in everything that happened with all other officers. Now, if she wants a comparator, if she wants to go, look what this officer did and they didn't get disciplined for it, that's fine. But this is not an appeal of the entire IA investigation. And I think Mr. Newcomb and I agree that when we approach certain witnesses, try to bring in certain witnesses, we can relive some of this argument. But I think overall, it would be nice for the commission to make a decision on whether Ms. Byrd can present argument or evidence that this party should have been broken up beforehand. That's all I have. Thank you.
If I can respond to that, I think it would be relevant whether the party should have been broken up beforehand, because that would have been a decision made by that man, Chief Harris there, and the command staff on how to react to the information they're getting throughout the day, or what information should have been passed through, where did the police department act appropriately, and if they didn't, are they trying to cover it up by punishing her and not accepting or showing anybody else at fault for that act? She's the only one that's been punished out of that whole thing. And you let guns run around town, you let it go on without any intervention from the top or any planning, and then they're the ones sitting in judgment and firing her. So some of that, just like her lawsuit being against them at the time and still pending, is relevant. Is there retaliation?
And that response further demonstrates what they intend to do, right? This is not about me. This is not about my response, about how I responded to a mass shooting where 2 people were killed and 9 injured. This is about what CPD did wrong and not breaking it up, right? That is a circus that they want to bring in front of this commission, and this is limited to her termination, her actions that day.
Thank you.
Any other,
Motions.
yes.
I was trying, I thought that's what you're gonna ask. I don't have any more motions, and I don't believe the city does, but I'll let, her, Ms. Decker, speak for herself.
I do not. I have a small housekeeping matter. Mr. Newcomb has sent an email, I believe, to Ms. Mabry Williams stating that he has 27, now 28 witnesses, and stating that he wanted the hearing to go on for 2 days. I just want that to be brought to y'all's attention. This is currently set for 1 day. If he is allowed to present 28 witnesses, and understand that doesn't include the witnesses that I would like to present as well, it will go very lengthy. Now I know commission, y'all can make decisions if we're going late into the night, or, you know, guys, y'all got 1 day full stop, although I think it'd prohibit me from presenting any evidence, I would prefer that that not be it. Or we're going to go over a couple of days. I don't even know with 28 witnesses plus mine if a couple of days will do it. And I just want y'all to be aware if y'all wanna start making plans for that, or give some advice on how to proceed.
Thank you.
All right.
Here it is. Okay, I think we've probably heard quite a bit of information today, and a lot of things to kind of decide now on, well, on this anyhow, about excluding any witnesses or not, or leave it at the 28, and we go 2 days and just see what they have to say, and we can still make a good decision, I think, on all the information that we do here. Y'all have any ideas on that?
My idea is that, you know, what happens at the commission, what the commission does is within the realms of what we're doing as opposed to what happened. Let's say, for example, let's take the witnesses first. I believe the commission should stick to why we're here, why the termination happened. The termination didn't happen on a totality of what we were presented. The commission should be looking at why this termination happened, and that only, and not everything else that happens. So with that said, based on council's motion, I think we should take a vote on that motion.
About excluding,
If I could, the chairman is the person that rules on the admissibility of evidence. So unlike a courtroom setting, the statute's very clear that only the chairman can do that. So this would be one of the things that the commissioners wouldn't actually take a vote on. The only thing that the commissioners would actually vote on would be the ultimate decision. So whether to uphold the decision or modify it, if that makes sense. And that's just the way the statute is worded. The legislature said that the chairman is the one that decides all questions about admissibility of evidence. Now, I think the chairman or chairperson can solicit the views of his fellow commissioners, sure. Just I didn't want us to get out of sorts.
Yeah.
And it's buried in the statute, so it's kind of hard to find. But yeah, the chairperson would have to make that call.
Well, I tend to agree with Dennis, as I understand it. You know, all of this big party stuff, that to me is an entirely separate issue of which this commission has no purview in. That's more for the city and the police department to review and decide if they should have or shouldn't have or whatever. There's such a thing as called discretion. Being an old Army soldier, we had rules and policies and procedures. And those were only as good and the plans were only as good until you crossed the line of departure and the first shot was fired. And then you reacted based on instinct and the evolving situation. Now, having said that, it seems to me that, as Dennis pointed out, what we need to do and focus on is the very facts of what she didn't do, what she was supposed to have done, and make a determination if the actions taken on those violations or proposed violations are valid. That's as much as I can reduce. I'm overwhelmed. This is my first encounter, first time I've seen any of these motions, I guess probably the rest of you too. And that's a lot to absorb in a few minutes. So as best I can absorb all this, and listening to both counsel, that's the impression I'm left with, that's what we should focus on.
So my question is, and Charles, you can help me out on this. What are we listening to this hearing for? Is it to determine wrongdoing or determine the disciplinary action as far as it was too intense or too?
So, both.
Okay.
The statute charges the commission and then later the circuit court if there is an appeal, right? With making essentially two rulings. One, whether to uphold the discipline, whether the violations did occur, which ones occurred. That the city would have to prove to the commission by preponderance of the evidence. And that's how I see it. So it's not strictly expressly bifurcated, but really that's probably the better way to do it. So first the commissioners would decide, was there rule violations? But then the commission and then subsequently the circuit court shares this discretion, has the authority to modify any punishment. So suspension could be dismissal could be reinstatement. So you're really making those two.
So what's Mr. Newcomb, what's he opposing? Is he opposing the actual?
Well, I can't answer that question. And here's why.
Okay.
So my role is strictly limited to providing legal advice to the Civil Service Commission, meaning that I can answer general questions like the one that you just asked,
Okay.
like procedurally. Or if someone were to ask me, what's the burden of proof that the city has to meet, I could answer that question. What I couldn't answer are questions that go to motions or arguments made by counsel, because then I would be usurping the role of the chairperson, which I can't do because I'm just a lawyer.
Can I ask him questions?
I have no objection if Charles does it.
Or can I just want to know is it she did wrong, or is it that how she got punished was not appropriate with?
So I think those are the issues, I don't want to speak for counsel, they're no smarter than me, but I believe that those are the issues that are being raised. And in general, those issues are matters for the commission to consider. Whether the employee violated the rules, and then, if so, whether the punishment was appropriate. So you're exactly right, if that was your question.
Yeah.
And the matter of pretext, for example, will go into that. That's something that the commission and certainly a circuit court later on, the Supreme Court's made that clear, that they can consider other evidence, including that the discipline that was imposed originally was not the result of the behavior, but rather the result of something other than the behavior, if that makes sense. And maybe not.
But if I may piggyback on Eric, that's what we do at the hearing, right?
Correct. You do that through the testimony of witnesses and presentation of evidence, and then at the conclusion, y'all would take a vote. But you would be voting on everything, not only the original rule violations, whether you believe that the city has met its burden of proving those rule violations by a preponderance of the evidence. But then you would also be reviewing, if you find that there were rule violations, whether the city's choice of discipline was correct.
But our reason for today is to agree or not disagree on these motions.
You can. The rules are not really clear on this particular pretrial motions, where they are in court, right? So as I see it, the commission has some options. The chairman has some options. He can rule on the motions today. He can hold them under advisement until they're presented at the hearing through the requested testimony of witnesses. So the chairman retains that. He's not required to make a ruling today, although he could. He could grant or deny any of the motions that are presently pending before the commission.
Well,
And one of those we've already covered with Ms. Kennedy, right? One of the motions we've already covered, so that's,
Yes,
Yeah.
it's
for the
ruled.
record, that's covered.
You ruled it already.
Now we're on the witness.
I think we're at the witness list that she is presenting for us for the hearing. And whether all of them are pertinent or not, I don't know. If like on the ones that they were standing right there by her and things had already happened or something, I don't know if that would be a good witness or not. So I don't know if it would be better just to wait until they're called possibly to rule on that individual.
Well, I may have missed something, but as I understand what council has told us, our function here today is to decide if you want to make that ruling, you as the chair. And if we want to limit ourselves to going into these hearings to look at specifically the policy that was violated, purportedly that resulted in the termination, and whether that was valid or not. And period dot. And everything beyond that, with all of the events leading up to the alleged actions, probably has no bearing on us. That would be probably more so in a circuit court if it should go to that at a later date. So I think what it boils down, and correct me if I'm wrong, Charles, but I think what we need to do today, or what the charge for us is, or for you, is to limit this to just, again, the policy that was purportedly violated, and to determine if those actions were correct or not, or valid or not, and nothing more. Not get all into this other issue of how it should have been handled, should have been broken up, and so forth. I think that's beyond our purview.
Yeah.
That's just my 2 cents worth. And if I've missed something or misunderstood something, council, correct me.
I definitely agree with that. I know a lot of this is gonna come out in the hearing itself, starting Wednesday, as far as what she did or did not do supposedly correctly or whatever to lead to termination.
And that may be the place for it,
Yeah. And it's,
not here.
But I mean, if it has to go 2 days, I'd rather it not, but if it has to go 2 days, I guess we'll probably need that time to go 2 days. Is my thinking.
If I may say one thing, and I don't disagree with you on part of it is did she break the rules? That's relevant. There's a second one, and I'm just gonna take it as an example of witnesses that she's maybe objected to that might be relevant, and I'll let the chairman make that ruling. You also have to decide what punishment would be appropriate for what you find that she did.
Not today.
No, not today, but some of the witnesses she's asking to exclude, I'm calling because they had been supervisors of her and would address what type of an employee she had been outside of that time, which may or may not be, in your opinion, and it's up to you, whether that would be important to decide what type of punishment to impose. That's why it gets complicated.
And that would be that'd be the relevant place for that to be discussed in her.
Yeah, I was just taking it as an example when you weren't addressing punishment is part of your job too, unfortunately or fortunately.
We confused you.
If I may further confuse y'all, hopefully not, I'm trying to make it more simple. Certainly, I object to a number of witnesses. I don't think the commission needs to necessarily decide each of those witnesses today. That's a lot. And I think, if Mr. Newcomb says he's going to call someone at the hearing, we're in the hearing, and he says petitioner's calling John Doe, then I can stand up and go, as we discussed at the last meeting, this is a witness that I have an issue with, that I object to their testimony, and then we can have a brief conversation about that because now you'll have the background on some of my objections. The only thing that I think would be helpful, but y'all are the commission, you get to decide what you want to do or not. I think it could be helpful to have some advisory statement that this hearing is going to be limited to what she did on that day and her response and whether she violated it, whether she violated policy. And then as Mr. Newcomb is correct, y'all will have to decide as well, if you find she did violate policy, was the disciplinary action, the termination appropriate? Now, we could go back and forth, and I'll save this until a hearing over issues of past conduct and performance evaluations and all of that. But I think for the purposes of today in my motion, it would be helpful to have an understanding if this is going to be limited to her actions, taking out, not saying limit on him presenting evidence of her past performance, we can get there at the hearing, but that for purposes of what happened on that day, that it's limited to her response on that day, the shooting, her response, and then her testimony or what she stated in her interviews, because that goes to the truthfulness, and how she acted in those interviews, which goes to insubordination. Anything prior about the party being broken up, I think it would be a waste of this commission's time, and it goes outside of what y'all are here to deal with at the time of the hearing.
If I may respectfully, I'm going back to a case, the case law goes back to the mid-60s. And the Arkansas Supreme Court said it was highly relevant for the commission in deciding, and the circuit court in deciding what punishment to give, to know what, and found that one of the reasons that justified the punishment that was ultimately given, not initially, was the person's work history, his prior disciplinary history, his conduct, all that occurred prior to that day. There is no doubt that this officer had administered roadside justice to a handcuffed prisoner in the jail. But they overturned his termination because of his employment history. So not allowing that, I think, would be a clear, contrary to what the law is. Now, that doesn't go to whether she's guilty or not guilty of any rule violations, but it goes to you all, and it's relevant to you all making a decision, and everybody wants to say, we can't talk about that, and I think that's not the law. And I want to make it clear, I think there's two things, and they can, one be admissible for one and not the other, but they still are admissible at the hearing.
And again, to be clear, I'm not asking for a decision today on that type of evidence. I hear you, Mr. Newcomb, and when we get to those witnesses, that can be discussed. But just today, I'm asking for a limitation on this is about what her response was, with the opportunity to address the issue of performance evaluations, prior conduct, prior disciplinaries at the hearing as well.
That makes sense.
Mr. Mason, if I could, y'all, these recordings only go on for 2 hours and then they automatically stop. So if we could maybe pause for 2 or 3 minutes, we've got several people watching online. I want to make sure there's no lapse in the recording. So it's going to stop here in just a minute. I have to hit live again. So if we could just maybe take a 3 or 4 minute just recess until we can get that live again.
That's where I say that most of us, I have a hard time hearing you.
And she would not be available to attend the hearing this week. I can't find it. Step out to my office and see if I can hear what I'll be right back. I thought you might want to know that.
Yes, I will. Thank you.
That way you're just getting.
We're just in a break right now. We have to change the video stream. It's about over though, it won't be much
I think
longer.
you just convene it
I
right
want to
there.
make sure you've been ready.
Hey, so it's a matter of.
Go in and do a little bit of discussion.
So, from my view, and they can talk about this, in my view, because the department has the burden of proof,
I'll tell you when I get out.
they probably should go first. And it's kind of like a criminal prosecution, the state goes first and then defense. And then, when that happens, you can go ahead and let the attorneys.
Please keep stretching. No, my husband has to say the same thing.
I'm old and fat.
Very tall.
Old and fat, I'm hurt.
Get over a chair.
Not enough, man.
Shoot, buddy, I played it over 50 deal, I've done it. Fort Worth and played in that. Oh, I was hurt.
I know how old you are.
10 years old.
Well, I keep letting
I was like, I know there's no facts. My brother is hurting.
I said, what are you gonna do in 2 years?
I'm limited. I'm
Get in on this.
I'm on borrowed time.
There it is. It came in my voicemail this morning before the meeting started. I didn't see it.
8:19 a.m.
My voicemails go to emails in my office, and I didn't see it until now.
Okay.
But she's not gonna be here the rest of the week
All
either.
right.
But this would be paid. My recession. She said she did, I just wasn't aware of it at the time. Can you see if you can get us live again?
Still.
I don't even know this girl. What's she look like?
Messaged Kevin to make sure that he could.
Yeah, they said there was a 2-hour limit. It still shows we're live.
Oh, that's her.
And so I wanted to make sure that it would either
Well, I'm
continue
obviously
on.
not biased at all. I don't even know who she.
Hey, Rebecca.
I'm making sure everything's recorded.
Yes, ma'am. When I was shaking my head, it was indicating whenever y'all are ready, we're ready.
Okay, so we're good. Yeah, I mean, yeah, I got it pulled up on YouTube and it's still on. Okay, I just wanted to make sure there was no lapse or anything like that. Cool. Okay. Yeah. Yeah, right, okay. I'll just leave it be then. Awesome. No, you're fine, thank you. Bye.
Thank you for your patience. Our meetings don't normally go quite this long.
Y'all are good to start back whenever.
We're live.
Okay. All right, welcome back, everyone. I did get a notice from Ms. Mabry Williams, that this morning at 8:19 that Ms. Kennedy did recuse from the hearing for the rest of the week.
She left me a voicemail.
Thank you.
Too bad.
We can say your motion is now moot. And it's not part of the, she didn't do it because of your ruling.
No.
No.
The other thing my client wanted me to point out, she wrote, there's at least 4 of the witnesses on our 28 that we've already eliminated, but your rule said, list everybody you may call.
Right.
And so, and there is also some duplication out of that 28 where we both have listed the person as a witness, and I can think of like Lieutenant Kennedy, and some of the others that we both may call. But I will also still concede we're probably talking 20 witnesses or at least between the 2 of us.
All right, is there anything else we need to discuss today?
I don't have anything.
Okay, I think we'll leave it like it is, and then hopefully we can get it done in one day, but probably maybe a day and a half, hopefully the most or something. But, I do, I guess, do we have any old business?
Mr. Chairman,
Yes.
I'm sorry to be a pest, but you had heard both sides on the issue of being more specific about truthfulness or the cause, and you didn't make a ruling at that time, you can take it under advisement. I just didn't want the record not to have it mentioned, cause you hadn't made a ruling, you don't have to make one right now, you can make it that day, but I just wanted to bring up that, clean up the record, as we say as lawyers, that hadn't been addressed.
Okay, thank you. But, okay. No old business, new business. I guess the new business we have is be here we'll be up front at 9 o'clock Wednesday morning. And anything else on new business? Do I have a motion to adjourn?
Make a motion that we adjourn.
Second.
All those in favor?
Aye.
All those opposed?